Welcome back, everyone. Can you hear me okay?
Yes, we can.
Oh, good. So, welcome Aaron and your team. I think Daniel will take us through the closing. Is that my understanding?
Yes, that's correct. We've got Mr. Lewandowski available as well if there were any questions, but as far from our perspective, we simply intended that I would take you through the closing submissions and addressing the additional points that have just arisen during the course of this morning.
Okay, very good. We have read them, Daniel, in the time-honoured way. Just go to the highlights. It would be good.
Certainly. And so, in terms of introduction, we've been conscious of not repeating matters in our opening submissions and to focus on new matters that have arisen during the course of the hearing. It does mean, and I'll come on to the MPS HPL, that essentially it becomes a bit of an amalgam because we did address you in our opening submissions and then those supplementary submissions on the role of the MPS and how to step through that, and we do comment further on it in these submissions. And so it is essentially a combination of those submissions on these points.
Oh, good.
The other point at the outset I wish to address you on was your key inquiry and the way on the first morning that Commissioner McMahon framed that as far as this key question of whether there is any fundamental impediment preventing the plan change from proceeding. And so we agree and submit that there is no fundamental impediment to the plan change being approved. On day one of the hearing, the panel also identified 3 potential issues. From our perspective, and we will take you through each of those and how you can be comfortable on them, but in our submission, despite the position of Ms. Barr, we considered that there is essentially one key issue that does remain outstanding, and that relates to activity status. So it's a secondary matter as far as, rather than looking at it if there's a fundamental issue and it coming down to what is the appropriate activity status. So now I propose to take you through what were identified as those 3 potential issues at the start of the hearing before covering off some of the other matters that have arisen. So the first one was infrastructure, and so this was raised as a potential key issue in the officer's report at the outset. Now there was, during the course of the hearing, the evidence of Mr. Brents, and then there was also the joint witness statement of Messrs. Brents and Rose that did confirm that those residual concerns held by Mr. Rose had been resolved. Despite that, the reporting officer addresses a residual concern as to whether these matters can be addressed at the consent stage. And with respect, though, hearing from Ms. Barr this morning, it does seem that she has misunderstood the issue and the relevance of the private booster pump. So when Mr. Brents presented evidence during the course of the hearing, he was very clear that the need for a private booster pump related solely to water pressure on the Welhom site. The question of effects on water pressure on surrounding areas was a separate point. And so, firstly, on the question of water pressure within the site, you will see at paragraph 2.3 of my submissions, I do address the rules in terms of subdivision and the corresponding New Zealand standards and the like, which address minimum firefighting pressure and the like. And so through those standards and the relevant resource consent triggers, matters of water supply and water supply pressure on site can be addressed. Separately, in terms of impacts on water supply on surrounding properties, the joint witness statement from Mr. Brent and Mr. Rose was clear that Mr. Rose's concerns in relation to water pressure on surrounding properties had been addressed through that further information provided. And so from Welhom's perspective and in our submission, that issue has been put to bed. The provisions in the district plan as they are provide the ability for council to, if required, impose a condition requiring a booster pump on site. But that purely relates to water pressure on site. And so I do make the point at 2.4 that, again, any future applicant is going to be incentivized to ensure that there is sufficient water supply pressure for its own site. And so that in my submission means that issue has been fully addressed, and you can have comfort in that regard. The second matter, and I may wish to add as well that if you do have any questions on these topics, I'm very happy to address them as we go topic by topic, if that's more appropriate for you.
Yeah, that's good. David, did you have anything on this one?
Yes, I do. Thanks for the antecedents there. Can you hear me okay?
Yes.
Good. You're coming through very booming. Maybe just my apparatus. I'm not too sure. But I can't turn you down, so I don't know if that's a good thing or a bad thing. Now, on the issue that this matter of water pressure on the Welhom site can be dealt with through a condition of consent on the resource consent, are we talking about land use or subdivision or both? And Mr. Lewandowski might be able to assist here in terms of what the rule framework that allows that to be considered. I presume it relates to a reference to NZS 404 somewhere on the plan.
Sure. So you'll see it footnote 1 of my legal submissions that has the cross references to the relevant plan provisions, both in relation to land use and subdivision.
Yes. Sorry, I missed that. Yes. And so they're both standards on both land use and subdivision.
Correct.
So, just to give me some comfort on that.
Yeah, so certainly. So the additional references, so under a land use scenario, failure to provide it would be a restricted discretionary activity under Rule 21.4.17.
21.4.17, restricted discretionary, failure to provide
sufficient water pressure.
Oh, yeah. Right. Yes.
And then under a subdivision scenario, again, a restricted discretionary rule activity under Rule 20.1.3E.
E. Right. Thank you. That answers the first part of my question. The second part is where the JWS addressed the water issue on surrounding properties, and I noted down that you said that that was addressed by further information being provided. Does that require, or does that acknowledge any particular rule in the plan? How is this issue captured in the plan and the district plan, if at all?
So it is not, as far as I'm aware, but the information that was attached to that joint witness statement of Mr. Brents and Mr. Rose.
Yes.
Provided comfort, so Mr. Rose was satisfied that his residual concerns would be addressed, that the additional take of water from the reticulated supply for the Welhom site would not have any meaningful impact on water pressures in the surrounding area. And so just refer you back, so the further information I'm referring to is the graphs that were attached to that joint witness statement. So essentially that joint witness statement concluded that there was comfort that there wouldn't be water supply pressure issues exacerbated by this proposal on those surrounding areas.
Okay, I'll go back and have a look at that JWS and those graphs. Thank you for that.
And one final point is, as far as the references I gave you, the other one is as far as what we're proposing in terms of the retirement village proposal. And so there, if you look at the matters of control in 5.53E, Romans 2 and 3 relate to adequate supply of water for firefighting, and then also provision of water supply, wastewater disposal, and stormwater collection and disposal. So that completes the loop as far as the various matters.
Yeah. Quite a bit of background noise there, Stephen.
Oh, I'm not hearing so much, David, on my system, but
Okay.
I think I'm looking around. Everyone's got their speakers off.
Okay.
I'm just listening through my computer speaker, not my ears. So that might be a difference.
Okay. So that's fine. Mr. Mahanick, yes, I've noted those matters of control that you've just listed: firefighting, water supply, and adequate supply of water supply, wastewater, stormwater. Thank you for that cross-reference.
Thank you. Should I move on to the next topic? Great. So the next topic is the NPS HPL. So do acknowledge that this is one of the first private plan changes to consider the NPS HPL, and I've already mentioned the coverage that issue received in our opening and supplementary submissions. Before getting into the detail as well, I do want to briefly address the Balmoral decision of Judge Stephen. In our submission, the court's observations in relation to the NPS are consistent with the submissions we made through our opening. And through those opening submissions, you'll have seen we took you through whether we fitted within one of the exceptions or whether the clause 3.64 criteria needed to be met, and you'll see that we acknowledge that we do need to work through those criteria in 3.64. The Environment Court in that case did also address, to some extent, the comments Commissioner Daishu raised in relation to natural justice and the transition of sorts as far as how the NPS came into force. It discussed that both in the context of a plan review and submissions being sought by parties seeking rezonings, which was the key focus in that case, but did also address private plan changes. The decision in Balmoral is clear as far as how the NPS HPL applies in those contexts, and that is reflective of the approach that we have outlined in our opening legal submissions as to how you are to assess this proposal. So that is in the context of clause 3.64A through C, and then 3.65 in our submission. There were questions this morning in terms of the permanent limitations and what that might mean in terms of the assessment. Again, the decision in Balmoral is clear as far as that LUC classification being the starting point. And so while the two soils experts did acknowledge those limitations, there was essential agreement that the site remained LUC3. But those impediments are relevant to the criteria, which I'll shortly take you to. So in terms of the criteria, first looking at 3.64A, Ms. Barr acknowledges that I think it was, the wording was, a strong case has been put forward as far as the retirement village demand, but raised some questions as far as the residential demand. In that respect, there are two key submissions that I wish to make. The first is that Mr. Heath did address residential demand, supply and demand. And wish to reiterate that that is both in his written evidence, but then also when he presented evidence, there was detailed questioning by the panel of Mr. Heath, and he took you through the various graphs, tables, and charts in his evidence and explain those further as far as the shortfall from a residential perspective and the contribution that this would make. And you may recall Mr. Heath talking about it only being a small number of additional residential sites that this proposal was providing, but every bit counted. And then the second submission on this point is that his evidence is the only expert economic evidence on these issues. And it hasn't been challenged by other experts in that field. And so in our submission, you can rely on Mr. Heath's evidence, and that is in relation to both the retirement village and residential components of the proposal in terms of this criterion. Moving on to criterion B. Again, you heard from Mr. Heath in detail during the hearing, outlining the various other options that were considered for providing additional development capacity. And his evidence is that there's no reasonably practicable and feasible option for locating that capacity elsewhere. And again, that evidence is unchallenged.
Just on that last matter, Mr. Mahinnick, and I'm just trying to refresh my memory, was Mr. Heath making that comment in the context of the existing statutory environment? The existing plans and strategies that are in place for Masterton?
So it does look at the existing live zoned environment as the baseline, and then looks at what are the alternative options for additional capacity being provided. And so that included each of the areas of potential expansion outlined through the draft district plan process, for example, as well as other locations as well. There was quite a number of different options that were considered by Mr. Heath as far as providing additional supply.
Thank you.
And the one final point, as far as the permanent limitations issue, that is relevant also to B in the context of looking at what reasonably feasible and practicable alternatives there are. You also have to look at what the LUC classification of those sites are compared to what we are dealing with. And so while we're LUC 3, the fact that there are permanent limitations will be relevant to that assessment as well. Then in terms of clause 3.
Sorry, Mr. Mahanick, I'm not quite following you there on that one.
Sure. So it's not simply a question of are there reasonably feasible and practicable alternatives, full stop. You need to also look at is there a reasonably feasible and practicable alternative that is a higher LUC classification, for example. And so the fact that we are at the very bottom end of LUC 3 is relevant as far as what other options there might be that you discard because they're a higher LUC classification.
Okay.
So if it were
higher in the sense of LUC 1 or 2.
So if it were an LUC 1 site that we were looking at, the threshold as far as what other sites might be relevant, you would be interrogating LUC 3 sites, for example, more closely because it's a less productive site. And so it is relevant that we are right at the bottom end of LUC 3.
Thank you for that.
Then, in terms of the third criterion, you heard from both Mr. Allen and Mr. Milner regarding the permanently compromised nature of the site. That is relevant to the consideration of costs and benefits of urbanisation. And so both Mr. Heath and Mr. Lewandowski have considered those, and their evidence is that the benefits of rezoning significantly outweigh the costs, taking into account, among other things, the potential productivity of the site that could be lost. And so again, that significantly compromised nature of the site is directly relevant to that criterion. And then those are the three criteria in 3.64. In addition, there is clause 3.65 that addresses the well-functioning urban environment consideration. You heard from Mr. Heath and Mr. Lewandowski regarding the need for the delivery of a well-functioning urban environment. In our submission, while Ms. Barr did comment on it briefly this morning, the evidence of Messrs. Heath and Lewandowski is the best evidence before you on this issue. And that evidence is that this clause is achieved by the plan change and the full rezoning of the site. Now I was going to move on to the next topic unless there's any further questions on the MPS.
None for me, Daniel.
Okay. So
Sorry, Mr. Hinnock. Inevitably, there's one from me. Are you going to comment on the potential tension between the MPS HPL and the MPS UD?
So you're absolutely right that there is a tension between them. They are both relevant national policy statements and you're required to give effect to them. However, the way in which the NPS on highly productive land does outline that very clear framework that is to be applied, and my submission does provide the guide for how to work through the inherent tensions between additional land supply versus the protection of productive soils. And so through the criteria that I've taken you through, the language used in those criteria draws from the NPS on urban development in terms of demand and looking at those assessments. So it is a situation where you do need to work through those criteria in 3.64, but in our submission you can have comfort that we meet each of those.
Thank you.
So moving on to transport and road safety, I think it's very clear that those are issues requiring careful consideration by the panel. Ms. Fraser this morning referred to speed and a reduction in speed having the biggest impact on safety. And I'll return to this question of the speed limit. One of the really critical aspects in terms of your consideration, though, is to ensure your inquiry is not focusing in isolation on what the safest option is. It's focusing instead on whether the plan provisions are most appropriate. And so while safety is clearly a consideration, it is not safety at all cost. At 4.2, I do go through Welhom's position in summary on the issues of transport and road safety. In particular on these points, Mr. Georgeson and Ms. Mewison have carefully considered the existing transport network, and importantly there was criticism that Ms. Mewison potentially didn't consider the fully consented build out of Cashmere Oaks. She has. Where they've got to is that the Cashmere Oaks subdivision relies on access through Cashmere Oaks Drive. That has already been considered initially through a consent process, and the council was comfortable at that stage without the need for a roundabout, as was Waikakotahi. They've then considered what the impacts are of the additional vehicle movements associated with full development of the site under the two different scenarios. And they were clear that the intersection can comfortably continue to operate without the need for a roundabout from an operational perspective. Then, in terms of measures to manage effects, there are a range of measures that can be implemented. And so at resource consent stage, it'll be open to the council to consider at that point, given the transport environment at that stage, the speed environment at the stage, as well as all the other factors, what is appropriate there. The matters of control proposed by Welhom have been responsibly by Mr. Lewandowski updated through the course of the hearing, having heard the evidence from other parties to respond to those matters and to provide additional rigour in terms of those provisions. Importantly, those matters of control are framed sufficiently broadly to enable the council to impose a range of mitigation measures, including a roundabout potentially, if that was considered appropriate. Two further matters on this that I do wish to address you on, arising from Ms. Barr's presentation this morning. The first relates to the redrafting proposed by Ms. Barr attached to her addendum report. So she has suggested redrafting of the matters of control, albeit converted to matters of discretion. Crucially, though, in terms of transport and the transport matter of control / discretion, what she's provided is additional specificity on different aspects, but hasn't in fact broadened the matter of control originally proposed by Welhom. In our submission, the matters of control as framed provide sufficient breadth for all the transport matters that we have been talking about through the course of this hearing to be appropriately assessed at consent stage. The other particularly notable aspect of Ms. Barr's presentation this morning was her suggestion that there was no ability to impose a condition requiring an upgrade on the state highway. From a legal perspective, with respect, that's incorrect. The matters of discretion or matters of control provide the scope for conditions to be imposed, and it is absolutely open, as both Commissioner Daisha McMahon identified. There are a range of other examples of consent conditions that require transport upgrades, whether they be to local roads or to state highways, to be required for a development to proceed. And in our submission, that fundamental misunderstanding from Ms. Barr does also go to the heart of the reliance that the hearing panel can place on her evidence, and I will come back to that. The other aspect I do wish to address you on in terms of transport at the outset is a matter that at the conclusion of the hearing initially, it was suggested that there were quite widely held views in relation to transport. But I think from the discussion this morning and some of the observations from the panel, the matters, the differences in opinion between the technical transport experts are quite subtle. And so it fundamentally then comes down to those matters of difference as far as the planning implications, which I'll come back to. At 4.4, address some of those matters where there is essential agreement between the experts. The one additional comment I wish to address comes out of comments by Ms. Fraser this morning in terms of the gap acceptance parameters, and wish to observe that row 15 of the joint witness statement shows that Mr. Georgeson appears to be taking a more conservative approach than what Mr. Connolly has suggested, who refers to the Ostroads standards. And so essentially the Ostroads standards set out a 5-second gap, and that's what Mr. Connolly has referred to. The SIDRA guidance that is referenced by Mr. Georgeson refers to a 5 to 6 second parameter, and in that 5 to 6 second parameter, Mr. Georgeson has applied a 5.5 second parameter, so it's essentially taken the midpoint, and that is more conservative than the Ostroads guidance. At 4.5, address the agreement essentially in relation to the operation, the efficiency and operation of the intersection. And you heard from Ms. Fraser this morning that it was good, I think was the term used as far as its operation, and well above or below, depending on which way you look at it, that threshold of getting to a level of service D where intervention might be required. The next section of my submissions addresses the issue of DSI modelling. It was certainly a focus of the case for Waka Kotahi. And at 4.6, do wish to emphasise the limitations of the DSI modelling that has been undertaken. In particular, that it doesn't consider the particular circumstances of this intersection, including its good safety history, and compare that to SIDRA. Do also wish to address that given the inputs that go into the DSI modelling that look at the speed environment, traffic volumes, and basic intersection form, it means that if you are proposing an increase in traffic numbers, which any development would result in, that will inevitably lead to an increase in DSI if you've got the same roundabout architecture and the same speed environment. So it does mean that it's particularly crude. And importantly, Ms. Barr this morning suggested that it reflected the mitigation measures proposed and said that the various measures proposed by Ms. Mewison didn't reduce the DSI. That's absolutely correct, because the DSI doesn't look at the various mitigations that could be proposed apart from intersection configuration and speed environment. The other observation this morning was by Ms. Fraser, who acknowledged that the DSI numbers were low, but then sought to highlight the issue of T-bone crashes as a further factor, having already considered DSI. In my submission, that question of the type of crashes that could result and the potential impact of those is the very issue that the DSI already factors in. So the DSI modelling looks at the way that intersections of this nature perform around the country, the types of crashes that can result, and the level of injury resulting from those crashes, and you were taken to evidence from the traffic experts on that. So the fact that the type of crash that might result from a right turn movement out, that is already factored into the DSI outputs that you have before you. So it's not a further factor to consider, having already looked at the DSI modelling. At 4.7, go into some matters of detail in terms of the DSI modelling. I didn't intend to address that further with you. And at 4.8, respond to some of the criticisms of Ms. Mewison by Council for Waka Kotahi. Do wish to address you though on 4.10. And that goes to responses to questioning by both Mr. Connolly and Mr. Landon Lane that the DSI outcomes under any of the modelling that was undertaken, whether that was Mr. Landon Lane's or Ms. Mewison's, that the DSI figures that resulted were at the low end of the DSI spectrum, and the differences were within the model's margin of error. So again, that should provide the panel with comfort that there's no fundamental matters of disagreement between the transport experts in terms of those modelling outputs. It also means that some of those subtle distinctions in terms of the modelling approaches of the various transport experts are not material to your ultimate consideration. At 4.11, then do address some of the outstanding matters between the parties in terms of the implications of the technical material. And at 4.11b, do make the point that there's been no suggestion from any of the Waka Kotahi witnesses or Ms. Fraser that there is a particular threshold that we're exceeding. And I think that's relevant in the context of looking at what the level of effect is, even though they're at the low end and the differences are subtle, is there some critical threshold that's being exceeded? And there is no evidence that that is the case. The third matter in terms of these differences at 4.11c goes to the appropriate measures to manage effects. And the short point is that the evidence of each of the experts is that there are a range of mitigation options available, and there isn't clarity of one particular outcome being inevitably required or being essential, irrespective of the nature of the proposal. So at 4.12, again, make the point that we addressed in opening that the case for Waka Kotahi does present a chicken and egg situation. Again, you heard from Ms. Fraser this morning as well, making the same point. In terms of those matters at 4.12, I think it's telling the comments by Mr. Connolly under questioning that in considering a speed reduction or what the appropriate speed environment is, that the first consideration was the speed of drivers. Now, in my submission, that becomes quite self-serving if you're letting the speed of drivers already there in a 100km/h posted area, determining what the consideration is of what the appropriate speed environment should be in the future and what the posted limits should be. I also address the issue of the nature of this section of State Highway 2, and in our submission, and based on the evidence of Mr. Georgeson and Ms. Mewson, that it is already peri-urban, and there was certainly questioning from the panel of the Waka Kotahi experts in particular on this issue, and even through that questioning, there was a softening of the Waka Kotahi position, and Mr. Landon Lane conceded that when you move south from the Arvida corner, the environment from his perspective transitioned from semi-rural to peri-urban and then becoming urban. Now, he didn't clarify as to at what point in that transition our intersection of focus sat, but there was acknowledgement that there is a transition through that stretch. And at 412E, in terms of Waka Kotahi's fundamental drive or fundamental theme that a roundabout is required, do observe that 7 of the 8 intersections to the south of Cashmere Oaks Drive are priority controlled T intersections, while the 8th is a priority controlled crossroads intersection. Equally, north of our site, you have the Arvida development, that some of these issues came up, and I'll come back shortly to that issue. At 414, just wish to reiterate the response from Mr. Connolly that he conceded that the transport effects of this plan change are not of such a magnitude that urbanisation of the area should not be contemplated. He also acknowledged that the measures to manage effects can be resolved at a later stage, providing the best solution is not compromised by the plan change. At 415, do address the point that I think Commissioner Daish questioned Ms. Fraser on, as well, as far as the unhelpful use of percentage increases when looking at the DSI changes. The other aspect, though, is the use of more than minor effect as a threshold for consideration by the panel. I think that came up on the first morning of the hearing that more than minor or less than minor is not a relevant threshold for your consideration. And so do observe that that was both in the Waka Kotahi legal submissions as well as in Ms. Barr's 42A addendum. And so returning to Commissioner McMahon's opening articulation of a fundamental impediment, none of the transport witnesses have identified a fundamental impediment to the approval of the plan change. And at the end of these submissions, I'll come back to some of the key questions in terms of transport and activity status tied to that in terms of your consideration. One further matter that got addressed in supplementary evidence from Ms. Spate following the initial hearing was in relation to the change of government policy in terms of speed reduction. And do make the point at 416B that there is a somewhat fickle nature of the political dimension to this, which contributes to the uncertainty we all face today as to what that speed environment might be in the future at whatever time a retirement village or residential development application is considered by the council. And so just rounding out transport in our submission, when the panel stands back and considers the transport evidence in its totality, it is clear that transport safety is an important consideration. However, it isn't clear precisely what upgrade or mitigations are required. And so that means that it is something that can be left for a later date. And in our submission, there's nothing to suggest that it can't be left for the resource consent stage. And because of the tie into the activity status points that I address later in these submissions, I will loop back to some of those points as well. Now, happy to address any questions on transport, but I do wonder, given that activity status is tied to it, and I later address those, it may be more appropriate to address the transport matters later on.
Yes, I agree.
So shifting focus to some of the other matters that have been raised. There have been comments in relation to MUGs and the draft district plan. And so there were comments through the course of the hearing and then again through the 42A addendum. Make the point at 5.2 that Ms. Barr's consideration in the addendum of the draft district plan is fundamentally flawed, in that in essence she treats our current proposal as if it were a resource consent and requiring it to be assessed against the relevant objectives and policies. And so finding that there is an inconsistency with those provisions. Now, in my submission, that is irrelevant. And the fact that equally, you're not assessing this proposal against the current district plan provisions for this site in terms of a resource consent. That is the very reason why we are seeking the rezoning to a residential zone. What I think as well, the references to both MUGs and the draft district plan are not being put forward by the applicant as a fundamental driver for this proposal. If you look back at the material provided, where we say those documents are relevant is that they identify the potential urbanisation for this site over multiple years in multiple different documents. We aren't trying to make something more of it than that. And so it was interesting this morning that Ms. Barr again confirmed that this area would be looked at for urbanisation, and it was a question of timing from the council's perspective, as far as 5 to 10 years was the timeframe given by Ms. Barr. It wasn't a suggestion that this area should not be urbanised. At 5.5, address the question of timing of the plan change against the district plan review. And so, particularly in the legal submissions for Waka Kotahi, there was a suggestion that this should be parked and left for the draft district plan or the district plan review process. In my submission, that is not correct, in the sense that the RMA recognises and provides for private plan changes to be sought. You also have the NPS on urban development, which directs councils to be responsive to unanticipated or out of sequence developments. Absolutely, there needs to be careful consideration of any private plan change proposal. That is exactly what we have all been doing through this process. It was notable, the quote taken from the Arvida decision and relied on by Waka Kotahi, seemingly to suggest that district plan review was the time for consideration of whether the land should be developed. And it's interesting in that that quote was taken out of context, and it was actually criticising Waka Kotahi's approach to that proposal, which was seeking to oppose development of that site in the same way we are facing opposition from Waka Kotahi as well. On the next issue of Subdivision Rule 20.1.5J, in my submission, this is again something of a distraction of sorts. You will see, though, my criticism at 5.8 and 5.9 of Ms. Barr's approach to that issue through the addendum report. Fundamentally, Welhom was simply seeking the council's confirmation of how it applied that rule so that it could make sure that that was addressed through its plan change. It relies on the council's approach, and so if that rule doesn't provide coverage, you will have heard Mr. Lewandowski's evidence that he said that he was simply relying on the council's interpretation of that rule as far as its applicability, and that even if that was not correct, he thought that through the controlled activity rule for broader subdivision that was sufficient. But in any respect, attached to my closing submissions are a new discretionary rule. So if you so wished, that can be imposed. Ms. Barr has done the same thing. The key difference is whether there should be mandatory notification of Waka Kotahi. In our submission, that is not necessary, nor is it appropriate, and particularly in this regard, Ms. Barr's suggestion that it's critical that Waka Kotahi is notified of this proposal sits at odds with the broader rule that for subdivision accessing a state highway directly, that doesn't require notification mandatorily of Waka Kotahi. And so that is important as far as reading the proposal before you in the context of the rest of the district plan architecture. My final point on that is that I agree with Ms. Connor in her comment this morning that you should have no concerns in relation to scope or jurisdiction to impose that discretionary activity rule, provided that it is specific to this particular site. And both the proposals by Mr. Lewandowski and Ms. Barr are specific to this site. Next issue in terms of the outline development plan. And so I address it briefly here, but I'll come back to it in the context of the buffer planting and then later on the comments on activity, the structure plan request. At 5:15, in response to Ms. Barr's comments about building or buildings plural, you'll see the provisions attached to these submissions address that issue. On buffer planting, our submission is that Mr. Bentley's evidence should be preferred on this matter to Ms. MacArthur, but do make the point as well this morning, Ms. MacArthur agreed that her preference was for landscaping or screening to be provided as a matter of discretion and providing that flexibility. And in that regard, direct you to 5.5.3E Roman 5 in the proposed provisions for a retirement village that are attached. And you'll see that includes the provision of landscaping, screening, and open spaces already as a matter of control. The next final other matter I wish to comment on is connectivity. The key point there, Mr. Georgeson, during the course of a hearing, took you through that Google Maps exercise of looking at the existing and potential future walking, cycling, and public transport connectivity opportunities for the site. Make the point that while it's been raised as a concern by Ms. Barr, there is no additional connection, for example, that Ms. Barr has identified as being necessary in terms of proposed development of this site. Also, briefly address you on financial contributions that might go towards connectivity opportunities in the future, and agree with Ms. Connor on those points. Ms. Fraser this morning also referred to footpath widening. Now that again is a matter that could be addressed through consent conditions under the current matters of control as proposed, irrespective of activity status. I was going to move then on to section 6, unless there were any questions on those topics. Excellent. So section 6 looks at appropriateness of the plan provisions in the context of section 32. Do wish to, at 6.1, just briefly address you on efficiency and effectiveness, because in my submission, and I'll cover it in slightly more detail shortly, but some of the comments made, particularly by Ms. Barr and Ms. Saint-Amand in the joint witness statement, don't necessarily reflect these concepts as they are properly understood in terms of efficiency and effectiveness. So effectiveness is measured by the contribution the new provisions will have towards achieving an objective. And then on the other hand, efficiency is a consideration of whether they will achieve those objectives at the lowest total cost or the highest net benefit. And tied to that is then the comments from the Environment Court in the Whakatane case. I addressed 6.3, building on the earlier case in Wakatipu, about how to go about this question of considering activity status in the context of section 32. And in particular, if there are instances where the purpose of the RMA is achieved and the objectives and policies are able to be met by a less restrictive regime, then this regime should be adopted. At 6.4 address, essentially it comes down to a question of what's the least restrictive activity status that achieves the outcomes sought. At 6.6, going to the heart of this issue, in the planning joint witness statement, Ms. Barr has taken, in our submission, the extreme position that effects from a retirement village are both complex and not well understood. With respect, that position does not withstand scrutiny. Retirement villages are common activities across the country. They're contemplated and provided for across a range of planning frameworks, including as controlled activities in a number of cases, including the Rangiora case that was provided to the commissioners. Ms. Barr this morning said that that Rangiora example wasn't relevant because it was a different traffic environment. With respect, we're not suggesting that those provisions automatically apply. Of course, there is a site-specific consideration required, but it is absolutely relevant to a question of, are the effects of a retirement village complex or not? Are they well understood or not? The other critical aspect, and this goes to the heart of the difference between Mr. Lewandowski's position and that of Ms. Barr and Ms. Saint-Amand, is that there are a number of criticisms of controlled activity status by Ms. Saint-Amand and Ms. Barr. Those concerns apply equally to restricted discretionary activity status. So one of those examples is, are the effects well understood? Because it's critical under either controlled activity status or restricted discretionary activity status that the matters of control or discretion are carefully drafted to cover those effects. And in my submission, there isn't a suggestion that in my submission, the evidence or the technical evidence isn't such that there is an uncertainty that means that restricted discretionary or controlled activity status can't be framed in a way with matters of control or discretion that covers all the relevant effects. And so when you go back to the criticisms of Ms. Saint-Amand and Ms. Barr in terms of controlled activity status, that is really important to have in mind. At 6.7, make the point that Ms. Saint-Amand's Section 32 assessment is focused solely on traffic effects rather than looking at the overall development. And at 6.8, just building on that earlier discussion, there's heavy reliance that Ms. Barr and Ms. Saint-Amand place on notification, ability for consent to be declined, and whether consent can be objected to or appealed. Now, on the first point of notification, the fact that a controlled activity status means council cannot notify consent application does not mean it's not effective in this circumstance. And that comes down to, which I'll come on to, how the rest of the provisions are framed. Ms. Barr and Ms. Saint-Amand have also taken the position that a controlled activity status is less efficient on the basis that conditions can be objected to and appealed. Waka Kotahi also raised concerns about a controlled activity being frustrated in the event that Waka Kotahi did not agree with the outcome and refused access. In response, and I think it's worth emphasising this point, none of those criticisms are unique to a controlled activity. In our submission, these concerns are irrelevant because all activity statuses considered can also be objected to and appealed in the same manner. The question is therefore whether it's comparably effective compared to other activity statuses in terms of management of effects. Where effects are well understood and readily manageable, a controlled activity status can be just as effective as other activity statuses. And in our submission, the need for an applicant to obtain necessary property and other approvals provides further comfort that an unsafe outcome will not be allowed to occur, which, if anything, strengthens rather than weakens the case for controlled activity status. The provisions as outlined and attached to these submissions ensures that Waka Kotahi's views would be known through the ITA process. there's a suggestion that if Waka Kotahi are in the room, that they'll necessarily accept or be happy with the outcome, or the outcome will be what Waka Kotahi seeks. I think the Arvida case, just a matter of a few hundred metres up the road from the intersection in question, is a particularly relevant example here. Through that case, Waka Kotahi strongly disagreed with the proposal put forward by the applicant there. The competing evidence was carefully tested and the council agreed with the applicant. So that is a situation where Waka Kotahi did not get its way. In our submission, that is no different to Waka Kotahi's concern in relation to controlled activity status, that the outcome of a controlled activity status might be something different to what Waka Kotahi is after. Also make the point at 612 that there is the ability for an application to be rejected if the detail of Waka Kotahi's views weren't provided. And as acknowledged by Ms. Saint Armand, there could be a request for further information to also garner further detail as to Waka Kotahi's views, if required, under Welhom's proposed provisions. It's become clear to Welhom that in its view, Waka Kotahi's concern regarding controlled activity status relates to seeking involvement in the subsequent consent hearing process. And in our submission, that's about gaining leverage and the opportunity to have another bite of the cherry, rather than about efficiency or effectiveness of the plan provisions. In that respect, Waka Kotahi's position is opportunistic, and that it essentially seeks to create an environmental bottom line that does not have policy support in order to have state infrastructure privately funded to meet the current objectives of Road to Zero. And on that, in terms of the assessment of the policy framework, do direct you to Mr. Lewandowski's evidence and the application itself.
Mr. Mahanick,
yes.
Just before you go on to the matters of control, I've got a question of clarification and a substantive question on these matters that you've just been traversing.
Sure.
In your 6.8, you identified the three factors that Ms. Barr and Ms. Van Armand have relied on in favouring some form of discretionary activity over controlled. And in 6.9, you assessed, and 6.10, you assessed two of those matters. I'm just struggling to see where you've assessed item B, the ability for the consent to be declined.
Sure. So on that, I had earlier, I haven't addressed it in that section, but I have earlier in my submissions suggested that there is not a suggestion by the transport experts that the transport effects couldn't be mitigated, and it was a question of what the appropriate mitigation was. And I will return to that at the close of my submissions as well, because I think that is a critical aspect. The differences in opinion between the transport experts are as to what the appropriate mitigation response should be. There hasn't been a suggestion by any of the transport experts that there is a fundamental transport issue that requires decline of the plan change or decline of a particular resource consent application. Their positions on those issues rely on the provisions being robust to require and allow consideration of the relevant effects. And in our submission, that is absolutely the case. And that is what I'll be addressing next as far as the breadth of the matters of control.
Okay, thank you for that. Second question is, might depend on what you say later on, but if what are the rights of waka kotahi in terms of objection and appeal on a controlled activity?
There isn't any. So there isn't the ability for them to be involved. However, from my submission, that does not necessarily compromise the effectiveness of the provisions, provided that the matters of control are suitably robust, and coupled with that, the specific requirement for the position of waka kotahi and its comments on the ITA to be obtained and provided to the council as part of the application documentation itself.
Yes, I understand that. I should have clarified. I meant objection and appeal on any ultimate decision made by the council, and the answer would remain the same, presumably.
Correct. Absolutely. And on that, even if there were a right of appeal, that does not mean that waka kotahi will like the ultimate decision in any event.
Yes. Does your answer change if waka kotahi are identified as an affected party either through an express rule under a controlled activity, or no, it have to be through an express identification under a controlled activity, wouldn't it?
And I understand that that is precluded, and I'll be able to dig out the reference as far as whether controlled activity status activities can have specific affected party notification, and I understand that that's not a lawful rule.
Sorry, not a lawful or not an unlawful? Is it legal?
It wouldn't be legal.
Okay.
And so that's why no parties have suggested that approach.
Just so that we're talking on the same thing. I thought, okay. So Mr. Lewandowski's not suggesting that that waka kotahi be identified as an affected party on a controlled activity. He's rather suggesting that there needs to be a process whereby their input into the ITA is obtained.
Correct. And so after the first day of the hearing, I think it was, when this issue first arose, we came back to you on day 2 with that further information requirement in terms of the ITA and the views of waka kotahi. In part, that was because that was seen as appropriate. It was also reflective of the RMA not enabling a situation where waka kotahi could be specifically identified through a controlled activity rule.
Thank you. That's very useful.
We'll move through to my 614 about the matters of control. Both Ms. Barr and Ms. Saint-Amand provide criticisms of the matters of control proposed, but fail to provide proposed amendments that address these criticisms. However, they then consider appropriate matters of discretion that could apply under a restricted discretionary activity status. Ms. Barr also considers that a restricted discretionary activity status would be the least restrictive activity status that would be appropriate. In our submission, and with respect, the concerns of Ms. Barr and Ms. Saint-Amand in relation to the matters of control are illusory. This is because the key concern of Ms. Barr and Ms. Saint-Amand relates to the ability to notify waka kotahi and not whether adverse effects can be managed through matters of control and discretion. And on that point, again, take you to the redrafting proposed by Ms. Barr attached to her 42A addendum that provides greater specificity in terms of the roading criterion, but doesn't actually broaden it out at all. And so in my submission, the breadth of the matters of control do provide the power and ability for council on a consent application to consider all of the matters that have been raised in terms of transport through the course of this hearing. At 6.16, address the question of whether a structure plan is necessary. On this point, it essentially comes down to the label between structure plan and outline development plan. In my submission, is of no significance. It does come down to really a question of detail and what additional matters are sought to be imposed or addressed through that. So in terms of those matters, in terms of boundary setbacks, the district plan already has standards for these. In terms of buffer zone planting, you heard from Ms. MacArthur and her preference for a matter of control or discretion. I've addressed you already in relation to the booster pump. And then in terms of the infrastructure interventions at Cashmere Oaks Drive, again, the evidence before you is that there are a range of potential mitigations that could be required depending on the range of factors at the time of resource consent. None of those potential mitigations are confirmed at this stage as far as exactly what is most appropriate in that sense. And so in my submission, it's inappropriate to be predetermining what the intervention should be through this plan change process. And so overall in our submission, the current ODP plus provisions attached to my submissions are appropriate, efficient, and effective. Stepping back, you do have a situation where you do have, particularly in terms of the planners, you've got quite different views from each of them. And it is a situation where you do need to consider those and work out which evidence should be preferred. And so set out some of the principles at 7.1 that have guided the Environment Court in the past as far as how to undertake that exercise. And at 7.2 provide a summary of that as far as essentially the question comes down to who does the panel feel persuaded is correct. At the end of the following paragraphs do address some of those, what we consider to be relevant factors as far as your consideration. And overall, going to 7.7, in terms of the weighting of the various matters, in our submission, the reporting planner's recommendation of decline, that was repeated again this morning in the section 42A addendum, is at odds with the expert evidence before the panel and the matters traversed at the hearing. It's also relevant, the various factors that I addressed earlier in these submissions about some of the concerns with the factual and legal positions underlying Ms. Barr's expert position. And so for those reasons in our submission, Ms. Barr's recommendation should be given little weight and the evidence of Mr. Lewandowski should be preferred. So as far as an overall conclusion, the evidence is clear that there are no fundamental impediments to this plan change proceeding in our submission. The Council's 42A addendum confirms that it is, or the position in the 42A addendum is disconnected from the evidence before you. And in our submission, the same dogmatic approach has been taken by Waka Kotahi through this process. No scenario has been provided that might justify decline of a future resource consent. Neither Waka Kotahi nor the Council's experts have articulated a specific threshold of traffic or safety effects that is incapable of being managed. That is because environmental effects from retirement villages and standard housing are well understood and are not controversial or significant. In our submission, that leaves the panel with the question of whether the provisions proposed are appropriate, particularly in terms of efficiency and effectiveness. Ms. Sainaman and Ms. Barr do not consider controlled activity status appropriate because, among other things, an applicant might not like the outcome and would need to appeal. That's an example of controlled activity status providing protection and working as intended. It's also an outcome that's not unique to controlled activity status. The other example was the delivery of an outcome that Waka Kotahi does not like. That is exactly what occurred with the Arvida decision. Waka Kotahi there fought tooth and nail for a roundabout, and that was not supported based on the evidence and the law in terms of that hearing process. Finally, the focus through the hearing from submitters and the council has been on potential adverse effects, and that's reflective of most consent hearings or plan changes, is that there tends to be a focus on the adverse effects. However, the panel must not lose sight of the significant positive effects should the plan change be granted. New Zealand's in a significant housing crisis. The plan change will provide substantial investment in the Masterton and broader Wairarapa economies. It's based on the evidence before the panel and our legal submissions. The panel should have comfort that the plan change request can be improved on the basis of the provisions attached to these submissions. And so just to close, I did wish to focus on 5 key questions that I think are particularly relevant to you in your consideration. And this is particularly in the context of transport matters and activity status. So the first one is, based on the expert evidence before the panel, is there any fundamental transport issue that warrants decline of the plan change? In our submission, the answer is no. Secondly, has there been any issue identified where, or any reason why the effects of a proposed development could not be managed through conditions? Again, the answer is no. In terms of the intersection, is there certainty as to what specific mitigations would be required to manage transport effects at this stage? And the answer is no. The fourth question is, do the proposed conditions provide scope for detailed consideration of transport matters and imposition of appropriate conditions, including a potential roundabout? And the answer to that is yes, they do. And the final question is Waka Kotahi involvement in a subsequent consent process necessary to ensure its effectiveness. And in our submission, the answer is no. And so on that basis, following Judge Kirkpatrick's decision in Whakatane, if controlled activity status can address the effects of the activity effectively, then it must be implemented as the most efficient and effective option to promote the purpose of the Act and enable people to provide for their well-being. So those were all the matters that I wish to address you on, but very happy to address or answer any questions.
I don't have any questions, Daniel. You've given us your legal view very clearly. I don't have anything I need to clarify, but just over to David.
Stephen, I'm in exactly the same position as you. I did try to jot down those questions very quickly at the end, Mr. Mahinick, but I'm sure I've missed some points that would be useful if you could provide those in writing. For example, on question 4, I think you wrongly used the term conditions. You said, do the proposed conditions provide scope of for dealing with conditions including eroded ground? I think you meant provisions.
Correct, yes. And I've just handwritten those questions following the discussion this morning, so very happy to have those typed up and provided. One other matter, just in response to the question earlier from Commissioner McMahon about whether Waka Kotahi could be identified as a party in terms of a controlled activity rule for notification. So it can't. However, there is the ability for a controlled activity status activity to potentially be notified in terms of special circumstances.
Yeah.
So it doesn't allow identified parties to be identified in the plan provisions, but there is a limited ability for notification of controlled activity consents.
Okay, thank you for that. It does strike me that I did have one question on your 5th question that you posed, and that's about the involvement of Waka Kotahi to ensure effectiveness.
Yes.
And you've answered in the negative. Is that based on Mr. Lewandowski's suggestion that they be that their thoughts be canvassed in terms of the PIA?
Absolutely, absolutely. So the answers to all those questions are in the context of the plan provisions as a whole that are attached to my submissions, and so that requirement for the views of Waka Kotahi to be specifically identified and incorporated in the ITA is an important part of that.
Yes, and how is effectiveness measured there, and from whose perspective is it measured in that last question?
So it is certainly not from Waka Kotahi's perspective as far as their aspirations. It is more as far as the objectives of the district plan.
So it's about the effectiveness of the process to achieve the objectives of the plan. Is it?
So yes, the effectiveness of the provisions and delivering on the plan objectives. And so the question I'm posing there is Waka Kotahi's involvement necessary to ensure the effectiveness of the provisions and achieving the objectives sought through the plan itself? And in my submission, the answer is no.
Thank you for that, and look forward to the written version of those.
Certainly.
Thank you, Stephen.
Yes, look, David and we have had a pre-discussion after assessing all of the information provided to us in writing previous to this summary or end of the hearing process. So I'm about to make some directions. And we think we've certainly heard enough information through the written evidence and the legal submissions, and nothing we've heard today has changed our view on that. So and I will make one proviso. We do need to double check the Balmoral decision just to see whether there's any sort of particular legal concerns we have with that. But putting that aside, if we're satisfied that we can proceed, our view is that the plan change requested should be approved, but on the basis that the activity status is restricted discretionary and with limited notification provided to Waka Kotahi, but without the need for a structure plan detailing any further details than the current ODP. So that's our position. To assist us with that, we would like the requester to prepare for us a version of the provisions with the RDA status for our consideration, and we need to set a timetable for that, and we will request the council in Waka Kotahi to give us any further observations they have on the matters of discretion, in particular that are provided in that. So I've taken, just to really cut to the chase, we've taken the position that we should alert the parties to that position and request as I said, the request of Welhom to come back to us with a set of provisions on that basis. So is that clear to everyone?
Yes, and that's a helpful direction that the panel has provided, and we can certainly comply with providing those provisions to reflect that.
Okay, so it's not a final decision in the sense that we just need to go back and double check those legal positions, but in the event that we do ultimately make those findings, which we're very persuaded by the evidence along the lines that we've just outlined, we will need assistance in the drafting of the provisions, and that's best done so through the requester taking the activity status and working in the matters of discretion and the other matters we've talked about today, but we'd certainly be assisted by any subsequent or a subsequent review of those and any follow-up suggestions from both Waka Kotahi and the council planners. So in terms of a timetable for that, what I'm thinking about, we do want to keep pressing ahead. Daniel, could you give us an indication? Is that sort of a week's work, do you think, or is it something we could have towards the end of next week?
I would have thought that it's potentially shorter than that, as far as the changes required, given the similar drafting of matters of control and matters of discretion. It is actually a reasonably straightforward exercise.
Yes.
And so, not wanting to overpromise for Mr. Lewandowski, but and maybe if he can kick me metaphorically if there's anything saying that doesn't fit with his availability, but if it were the first half of next week, so say by next Wednesday.
Yes, that would be suitable. And from the Whakakatahi's and council's perspective, if we had that delivered by close of business next Wednesday, would you? What's your position? Would you need into early the following week to come back to us?
From my perspective, that would be fine.
Megan?
Apologies, our microphone button just didn't work there. Yes, that's fine with us too.
So if we said by close of business Monday the 8th, and we've certainly been assisted by the legal submissions, and certainly Rachel, your submissions about the future flexibility around financial contributions, we're quite encouraged by that, and on the basis that certainly to some extent the financial contributions do need to be applied to the effects of the proposal, and we recognise there's a balance there, and there's nothing we can direct the council to, but those, as a matter of course, those sorts of issues will need to guide how the council might apply financial contributions if a final resource consent is granted. So look, I think I'll leave it there. Are there any questions or comments from any of the parties from here?
No, thank you, commissioners.
Yes, and I hope that has been of assistance. Like, we could have gone away and come back to you in writing, but we thought we'd better to just keep the process moving from a efficient decision-making perspective.
Much appreciated.
We'd like to thank you as well for that. Yep.
Yeah.
Likewise,
All good.
Whakatahi would like to thank you too. It's great to get the direction early.
Okay, thank you. It was always a bit risky for us doing this, but I've seen other decision makers more experienced than me do this type of thing, and it is helpful, I know, to the parties. So thank you very much for your attendance. We will close the hearing pending the receipt of that information, and we'll certainly be on the job pretty well straight after. I've got a week leave starting the 8th, but the following week I'll be working with David on final deliberations and getting a decision through as soon as we possibly can. Thank you, everyone. Have a good day.
Thank you.
Thank you.
Thanks very much.
Thank you.